The Assembly Committee on Education is convened. At this time, I'll go ahead and pass it to Secretary Lindsay to take the roll. Thank you.
Assembly members De Silva, here. Dahlia, here. DeLong, present. Flanagan, here. Hanson, here. Hardy, here. Hunt, here. Koenig, here. LaRue Hatch, Mosca, here. Orntlicker, here. And Chair Torres Fawcett.
Welcome to the audience here in Carson City, those joining us in a very full room in Las Vegas, and those listening over our YouTube today. Couple housekeeping items. Please don't forget to silence your electronic devices. If you wish to testify, please sign at the table by the door and provide a business card to our committee staff at that corner. So if you haven't already signed in and you do plan on testifying, please make sure, or talking in public comment, please make sure you sign in. It makes it a lot easier on our staff. Electronic copies should have been submitted to our committee manager yesterday. Members of the public may provide testimony on a bill either in person or by phone. Please see the meeting agenda for the telephone number and meeting ID. Meeting agenda and committee information is available on Nellis, which can be accessed through the legislature's website. And if you're not already joining us and following our YouTube channel, please don't forget to subscribe. There's still time. We only have like 5 weeks left. Public comment will be taken at the end of the meeting. Each person will be limited to 2 minutes. We expect courtesy and respect in our interactions at the meeting, even if we do not agree with another person's position. Committee members will be using their laptops to view handouts and other documents. Please don't view this as a sign of disrespect or inattention. I will also note that I have several committee members that will have to leave at different times for bill presentations in the second house. So please don't view this as a sign of disrespect or inattention. But obviously, the closer we get to deadlines and the closer we get to sine die, our committee members are kind of pulled in multiple directions and have to be a little bit of everywhere all at once. With that, we are going to be going in order today. So I'm going to go ahead and start with SB 115. So I'll go ahead and open the hearing on SB 115, and I'll invite Senator Cruz Crawford up with any co-presenters.
Thank you, Chair Torres Fawcett and the Committee on Education. For the record, my name is Shelley Cruz Crawford. I'm the senator from Senate District 1 in North Las Vegas. And today I am happy to present Senate Bill 278, which is a culmination of 115. Just kidding. 115, which is a culmination of a lot of work that I've been doing across the state of Nevada, which is to build a framework for dual language. And dual language is defined as teaching 2 languages simultaneously in a program of study, and those can be a myriad of programs. And as I've been researching how to create programs for schools that would like to implement them, for a plan 3 years prior to the implementation stage to growing grade levels, I have been able to visit states that do it really well, which is Texas, Utah, New Mexico. And what I've learned is that a lot of the states fund at the state level for dual language. Well, guess what? We can't do that right here, right now. So we have found an alternative measure, which my intern, Brandon Michelle, will go through shortly, and the benefits from Dr. Sanchez from UNR. But right now we have basically what the bill does is there's already if there is money available at a school, they may provide a stipend. There's 6 schools within the state of Nevada this actually applies to right now that do have dual language programs, and the teachers have to translate their curriculum in order to teach them in 2 languages. And so this is a school-based decision-making model out of school-based funds. And so to allow them to do that. The second part of the bill streamlines and puts into place what is already in NAC into NRS. Right now, if you are teaching in a bilingual program, you need to have the bilingual endorsement on your license. There is some confusion because NRS says you need a bachelor's degree, where the NAC, the Department of Education, says you need the endorsement. Those of us that are educators here know that most educators get their degree in something else, whether it's elementary education or engineering, and then they go on to add endorsements to be able to teach other programs. So this just aligns that language together so that if you are getting a bilingual endorsement, you need those endorsement credits. You don't need an additional bachelor's degree because that doesn't make sense for career advancement. So I am going to turn this over to my first presenter here, Dr. Sanchez. She has about a 5-minute presentation, and then my intern, Brandon Michelle, will go through some portions of the bill directly. Thank you.
Good afternoon, Chair Torres Fawcett and members of the Assembly Committee on Education. For those of you who don't know me, I'm Dr. Jafet Sanchez. I'm the director of the Latino Research Center at the University of Nevada, Reno. It is the only one of its kind in the entire state, and we're really proud to be able to share information to help others make informed decisions, such as today, which focuses on bilingual education. So to begin, I share a picture of my own experience when I was a classroom teacher, high school math teacher, and our school site was a newcomer intake center, as it was called, which included a lot of students, as you see there, who are from bilingual backgrounds. And I emphasize that oftentimes we have not only bilingualism, but of course multilingualism. And we see this with half of our global population having a bilingual or monolingual multilingual context. When we think about the benefits of bilingual education, I begin by centering on emergent bilinguals because emergent bilinguals acknowledges that people have a multilingual lens, not necessarily that there's preference over one language versus the other, which has often happened historically in our education context with areas like English as a second language, which emphasizes the additional language versus both. So that's really important in bilingual education because we think about what translanguaging means, which truly means that it's an emphasis of really engaging all of those linguistic aspects. And so in bilingual education, there's an opportunity to create this multilinguistic awareness aspect of the students who are engaging in those classes. That means they also build a stronger sense of awareness and they're able to capitalize on those academic benefits, which oftentimes tie into comprehensive skills. And at the same time, it builds their identity. So they end up having these stronger experiences across their educational landscape. Other benefits then that we see is when we look at these emergent bilingual students in bilingual education programs, they actually outperform their peers when they're in the English language settings. And this happens in those core essential classes that we know are math, ELA, and we see it beyond those core classes. We actually see that they are able to graduate from high school at higher rates than their counterparts, and that they're able to access higher education at stronger levels, which is what that HE is listed there as. For improved cognitive skills, they have the opportunity to generate just extensive problem-solving skills, and it allows them to have this enhanced cognitive ability where they're basically multitasking. They're able to engage in different ways that has allowed them to just capitalize on, again, their multilingual lens through bilingual education. And they have an increased cultural competency that allows them to just navigate different spaces and have stronger understandings of these cultural cross-understandings that lead into stronger community engagement, not only while they're in those school settings, but beyond those levels of their school settings. Other benefits that come to mind are with that increased opportunity for identity formation, they have this stronger sense of self that then allows that to translate into other things, including their home language. They no longer see their home language as a deficit to what they're trying to do, but they see that as a mutually beneficial process of what they're doing within the education setting and beyond. So that ties into increased economic opportunities, which makes sense. They have access to different types of jobs, and they're also able to command higher salaries. So when these opportunities come to them, they're able to be in settings that allow for stronger linguistic diversity within those types of contexts. Then we think about the budget side. For these types of programs, they actually are seen as comparable, if not less expensive or at a lower cost than other programs like what we've seen traditionally are considered English language learning or English as a second language. In this case, bilingual education actually has those increased benefits and can be comparable in terms of cost-effective models. Then we have to think of the monolinguals, because the monolinguals are part of this bilingual education setting. It is intended to be equally beneficial, and we see that in terms of benefits. Monolingual students who initially had only English speaking skills but are in these classes also gain those executive function skills where they're multitasking, they're problem solving, they're gaining the linguistic capital, which when they're now adding this other language construct and linguistic capital, they're able to apply that into their English writing skills. I used to do that in spelling tests. I would have the spelling test in English, but I could spell it out in Spanish, and that would help me always get every letter right. So those things we see are then leading into those improved English literacy skills. And within the English-speaking students, when they're in their monolingual settings, they're still outperforming their students. So we see those long-term economic advantages playing out all the way through their ability to just be globally competitive in the market that we see today and having that increased diplomacy. So with that, I will conclude on some of the benefits of bilingual education. Thank you.
Shelley Cruz Crawford, for the record, I will turn it over to my intern Brandon Michelle to go quickly over the portions of the bill.
Brandon Michelle, for the record. Now I will walk the committee through the bill. First, Senate Bill 115 requires the Commission on Professional Standards in Education to adopt regulations requiring teachers to have an endorsement in bilingual education in order to teach pupils enrolled in such a program. The provisions mirrors what is already required in Nevada Administrative Code. The bill also authorizes a school district or a charter school governing body to provide an annual $2,500 stipend to teachers who hold such an endorsement and teach bilingual education. Any stipend provided to the teacher at a charter school or a school in the in a district with more than 100,000 students must be paid from the school budget. Lastly, the bill requires school districts and charter schools to report the number of employees who receive such a stipend for certain entities.
Shelley Cruz Crawford, for the record. Thank you, Chair and Committee. I sit for any questions.
Thank you. At this time, I'll go ahead and take any questions from the committee. Assemblymember Mosca.
Thank you so much, Chair, and thank you, Senator and team, for this bill. Probably just a clarification for me. I know you had said it's a site-based decision. So what impedes principals from just using their budgets to pay it out if they wanted to?
Shelley Cruz Crawford, for the record. Thank you so much for asking that. I have worked with all the unions collectively. Usually unions work through negotiation, like we have the teacher stipend right now, we have the support staff, the administrative. This just allows it at the state level, but I have worked with all the teacher unions and they are on board with this. Typically, you would not be able to pay a collective bargaining employee differently than another employee. Thank you.
Assemblymember De Silva.
Thank you, Chair. And again, thank you for the great presentation here. And you got a solid team there with you. It's always great to see that dais full. Just again, for the general public out there, so what are some of the ways that you can go about receiving one of these endorsements to be a bilingual educator? Thank you.
Shelley Cruz Crawford, for the record. This is my passion. I started a dual language program several years ago on my school, and I had a lot of teachers that didn't have the endorsement. So we've worked through. Nevada State University is the first and only university in the state of Nevada that does an undergrad bachelor's degree. We are about to graduate about 300 students. So we are on the forefront of being able to create dual language programs across the state of Nevada. And that's why this legislation is so important and part of that framework. They can go to UNR and they could get the credentials through the Nevada Department of Ed, the required coursework. And we also have Jeff Brisky from the Nevada Department of Ed. He is down south in Nevada to answer any licensing programs. But really, any of our NC University, any of the classes that are available that are required through the Nevada Department of Ed, they can take through our classes at NC.
Thank you. And I'd like some clarification. So which institutions do offer classes that meet the requirement? And I have opened the NAC, so I'm taking a look. So that would be like methods of teaching language arts or reading in a native language, methods of teaching math, science, social studies in native language. So they would have to take up to 12 credit. They're required to take at least 12 semester credit hours in order for them to get that endorsement. So which institutions offer those courses?
Shelley Cruz Crawford, for the record. My teachers have taken classes from UNR, UNLV, and Nevada State University. Those three I know for sure, but I can get clarification because they are 300, 400 level courses. They're mostly from those universities, but I'll also see if our other colleges have those courses as well and get that back to the committee.
Thank you. Members, any additional questions? Assemblymember Hanson.
Thank you, Chair. Thank you for being here. Maybe you could just, I want to make sure I'm not getting confused. I'm familiar with dual immersion, and this is different, right? And if you could just kind of, I'm not familiar, like, I know some of my grandkids went to a dual immersion school in Arizona where the students opt in and they're taught in most of it in another language. It was an amazing experience. Can you just give me an anecdotal of how it looks if we do this?
Shelley Cruz Crawford, for the record. Thank you so much for this question. I could nerd out about this all day long. So how we approach this in Nevada right now through the framework we're creating, and she can add it, is that what we want is the ideal model is a 30-30-30 model. 30% of those are the native speakers of the one language taught, 30% of the other language that are taught, and 30% or 33%, I guess, of teaching both or in both languages. That's the ideal. We don't always have that. But the method that we use within CCSD right now is we do the 50-50 model where they get 50% in their native language and 50% in the new language. And so this is a benefit for both English speaking students and those that speak those native language. If you think about a student that just has English and then they're getting in a Spanish program, they'll still be getting 50% of that curriculum, so they're still learning the content. Same thing with our Spanish speakers. Right now, traditionally, we put them just in English. So there's several years where they're not really 100% understanding the content. This helps support them through that process so that they have English and Spanish. And then I would like Dr. Sanchez to add anything else that she would like. So it's very fluid on what you decide, but it sounds very similar to what we're trying to achieve here.
In terms of the delivery model within the classroom, it is very similar, but the difference is that when you have a two-way immersion or the immersion program that you mentioned, it has to have a linear trajectory, which usually they begin in kindergarten, for example, and then that's an alignment across the different programs or school levels, whereas in bilingual education, it can be just one targeted classroom, like she's mentioning. So there may be a math language that's all bilingual education in that one, and a science one that's bilingual education. But it doesn't mean that the students all were derived from this program where they started from the early stages of their programming and things like that. So that's one of the structural pieces that also distinguishes the two-way immersion versus a bilingual education.
Shelley Cruz Crawford, for the record, to put it simply, is we want them to end up bilingual in across all content areas.
Thank you for that. That helps a lot for me to understand it. And then mostly in the elementary level, or are you doing this, is it done sometimes in the middle and high school? Or you hope to have it done throughout?
Shelley Cruz Crawford, for the record. Right now, we're running pilot programs where it is in feeder alignment schools. So the elementary that feeds into the middle to the high school will have these programs. Thank you for asking.
Interestingly enough, just this weekend, I was having a conversation with a good college friend, and her husband is a math teacher at a high school in northern Nevada, where he provides dual language instruction to high school math, and students opt in when they're in the IB program, and then you have some students that are also taking that class that are not. So I think there's a lot of benefits to bilingual education, but I wanted to follow up on some of my questions. My question earlier, just regarding the licensure for bilingual education. How many teachers in the state of Nevada right now have an endorsement to teach bilingual education?
Shelley Cruz Crawford for the record. I don't know if Jeff Brisky from NVDOE can come up and answer any of these licensing questions. He might not have the exact number, but he is a wealth of knowledge.
Good afternoon, Jeff Brisky, ND, for the record. I'm the Educator Licensure Director at the Department of Education. I do not have those numbers, but I did want to come up and get my name on the record that I do not have those numbers, but I can get those back to you by staff within the next day or two. So thank you for asking.
Thank you. I guess my concern, now what I just want to make sure is that we have enough licensed teachers to fill those roles, because my concern would be that you put an extra barrier that then makes it more challenging for us to open dual language schools. So I almost wonder if it should be that have a license and or are working towards getting that bilingual education license, because otherwise we're saying you have to have already had this, and you might have an excellent teacher that a principal has confidence is able to teach this quality of instruction in two languages, but then they wouldn't be able to execute that plan because those teachers don't have licensure. So you would actually just get rid of those teachers and then fill them with subs. Or you could. I mean, I'm hoping that wouldn't happen, but you could.
Yeah, and if I may, please, Jeff Brisky, ND, for the record. I know it's over 200 right now licensed bilingual teachers. With the exact number, I can't tell you that, but we have more than enough teachers who are currently licensed with Nevada State graduating cohorts all the time to fill those vacancies for any new programs that may be built.
Thank you. And how about do you have it broken down by primary and secondary? Because I've heard specifically with concerns with secondary programs, not being able to find the instructors.
Yeah, Jeff Brisky, ND, for the record. I will look into that too and get you all that data over to staff.
Thank you. I appreciate it. Members, any additional questions? Assemblymember DeLong.
Thank you, Chair. Thank you for the presentation. Just trying to understand between the original bill and the reprint, there were quite a few fiscal notes on it. Did the amendment address the fiscal note issues?
Shelley Cruz Crawford for the record. Yes, it didn't come out as my intent was always for it to be a site-based decision. It didn't come out as my exact intent, so the amendment removed that fiscal note. So thank you for asking.
Thank you. Thank you, Chair.
Thank you. Members, any additional questions? Seeing none, at this time we'll go ahead and move on to support. Thank you, Senator. So we'll invite anyone wishing to testify in support to SB 115.
Thank you, Chair. I am Brian Wallace, middle school teacher and vice president of the Nevada State Education Association, who has represented educators for 125 years in all 17 counties. NSCA supports SB 115 to allow school districts to provide $2,500 stipends for teachers in bilingual education programs. As the presentation demonstrated, there are amazing benefits to the program, especially being able to in fostering a climate that values the diverse needs of all our students. SB 115 could also be a significant step in continuing building the bilingual education teacher pipeline in Nevada, as well as continuing in recruiting and retaining the ones that we currently have. Thank you.
Good afternoon, Chair, members of the committee. For the record, Alejandra Rodriguez, Nevada System of Higher Education, and she is in strong support of SB 115. We'd like to thank Senator Cruz Crawford for bringing this forward. And to the Chair's question previously, we can get her specific information from our institutions. Thank you.
Thank you, Chair Torres Fawcett, members of the Assembly Committee on Education. Austin Daly with the University of Nevada, Reno for the record. We are in support of SB 115 as the bill provides additional resources for bilingual teachers in Nevada. In order for bilingual students to achieve their educational goals, we need to make sure we are supporting the teachers doing the work in our K-12 schools. We are proud to be in support of this bill. We want to thank Senator Cruz Crawford for introducing the bill. Thank you.
Good afternoon, Chair Torres Fawcett and the Hard-Working Committee on Education. For the record, Leonardo Benavides with UNLV, here in support of SB 115. The UNLV College of Education in particular supports the bill because it provides a permissive structure for schools and districts to support licensed educators in bilingual education programs and strengthens endorsement requirements for bilingual instruction. Nevada's growing multilingual population includes over 80K emergent bilingual students, nearly 20% of our public school enrollment, making it imperative to recruit, retain, and support qualified bilingual educators. Research consistently shows that students in well-implemented bilingual programs achieve stronger academic outcomes, yet Nevada faces a shortage of teachers prepared to meet these needs. At the UNLV College of Education, we are committed to addressing this gap through initiatives like Project Pueblo, which has prepared head teachers with specialized training to support emergent bilingual students. Our programs work to equip educators with the skills necessary to promote academic success of bi- and multilingual students, ensuring Nevada's workforce remains competitive in an increasingly global economy. SB 115 makes an important and intentional steps toward recognizing the expertise required for bilingual instruction and creating the permissive structure for schools to support incentives when available funding exists that attracted and retain these highly skilled educators. By investing in bilingual education, Nevada strengthens its commitment to equity, economic opportunity, and the long-term success of our students and communities. We'd like to thank Senator Cruz Crawford for bringing forth, and thank you for time.
Thank you for wearing Nevada blue.
Good afternoon, Chair Torres Fawcett, Vice Chair De Silva, members of the committee. My name is Wesley Harper. I am the Director of Government Affairs for the City of North Las Vegas. We thank Senator Cruz Crawford for bringing forth this bill. We echo the sentiments that have been expressed thus far, and we agree with the contents of the presentation. This bill helps strengthen and expand the academic performance of our residents, and therefore we are in support. Thank you.
Hi, I'm Melinda Bauer, a teacher at McQueen High School here in Reno, Nevada, and a member of the WEA. I was actually just here for some lobby meetings and heard this was being heard, and I really wanted to stop by. I'm a Spanish teacher. I'm an EL teacher. I think that I would absolutely be in support of this. As we know, our bilingual programs and our Spanish programs are continuing on the chopping block. However, at McQueen, I was able to bring back my native speaker Spanish program, and I have 40 students enrolled, and we identify and talk about the Latino culture and really help these students fit in as they're coming from other countries in into our city. And so it was awesome to hear that this has been brought forth, just really respecting our bilingual educators and being able to understand that we provide services to all of our students, whether they are learning a second language or in a bilingual program, even in our public schools. I think that it could be expanded hopefully someday to include our public school system. Regular Spanish or bilingual programs that we house in each and every school. But I think it is an amazing start to be able to support our bilingual educators in these single house programs and the bilingual and dual immersion programs. So I just really wanted to say thank you so much for valuing us and seeing us, and yes, I would absolutely support it. So thank you very much.
You, Chair Selena Torres Fawcett, and members of the Assembly Committee on Education. My name is Nathan Carrillo, also on behalf of the University of Nevada, Reno, for the record. I support this bill as it is important for Latino educators, or just teachers in general, who support our Latino students and Native students. It's important to provide them with this extra stipend because it is very difficult even with their teacher salaries. And providing this bilingual education will help foster inclusivity and empower our students, our students that speak Spanish and are trying to learn the new language of English. It will only help them to navigate the world better. And as I've seen it within my elementary school that has students come from different countries, especially Mexico, and they have felt they have felt better when they are able to speak to somebody in their language. They have learned better, and they feel that they are adjusting better to the world, the language, the people around them. Everything's different. So helping our teachers, providing them with this stipend is very important. So I definitely didn't want to give thanks to Senator Cruz Crawford and Donate for supporting this bill. Thank you.
Good afternoon, Chair and members of the committee. My name is Tara Webster, Tarawebster. I'm the Policy Manager for the Progressive Leadership Alliance of Nevada. On behalf of PLAN and as a member of the Nevada Immigrant Coalition, we're proud to support SB 155. In my past life, prior to working in policy, I was a science educator and researcher, and so this is a really neat bill, and I'm so happy that it's here. While this bill expands professional opportunities for educators, it will really help students to achieve proficiency in different languages, improve academic performance, develop their literacy skills, and deepen connections to their culture while learning about other cultures. Thank you.
Seeing no one else here in Carson City, I'll go to Las Vegas. Is there anyone wishing to testify in support of SB 115? Seeing none, at this time I'll go to the phones. ABH, is there anyone on the line wishing to testify in support of SB 115?
Thank you, Chair. If you would like to testify in support of Senate Bill 115, please press star 9 now to join the queue. Chair, there are no callers choosing to testify at this time.
Thank you. At this time, I'll go ahead and go to opposition. Is there anyone wishing to testify in opposition to SB 115? Seeing none here in Carson City nor in Las Vegas, ABH, is anyone on the line wishing to testify in opposition to SB 115?
If you would like to testify in opposition to Senate Bill 115, please press star 9 now to join the queue.
Hello.
Please proceed.
Hey, how's it going? Sorry about this. I don't know if I'm requesting to speak regarding the right bill, but I have a request, and I was told to contact you guys at this committee today. There's something.
Can you
on
please
the
state
book
and spell your
that
name for the?
allows
Can you
kids-
please state and spell your name for the record?
Sorry about that. Yes, my name is Ashniel Manning, Ashniel. Last name is Manning, Manning. Can you guys hear me okay?
Yes, please proceed.
Okay. So my son, he's a straight A student, and recently there was a soft lockdown given something happened in the area with a gunman. Prior to that, there was
Sir, this is about bilingual education. Is this the bill that you wish to speak on today?
Is there any time I'll be able to raise this issue today?
Is this about bilingual education and this specific bill? If it's not, we have public comment at the end of the meeting.
Oh, at the end of the meeting. Okay, I will wait till the end of the meeting.
Thank you.
Forgive me.
Thank you. We can go ahead and strike those remarks from the record for this at this time, and we'll go ahead and continue in opposition to SB 115.
Thank you, Chair. There are no additional callers to provide testimony at this time.
Thank you. At this time, I'll go ahead and go to neutral. I do not see anyone here in Carson City, nor do I see anyone in Las Vegas. AVH, is anyone on the line wishing to testify in neutral to SB 115?
Thank you, Chair. There are no callers to provide testimony at this time.
At this time, I'll go ahead and invite the bill sponsor for any closing remarks. She's yielding her closing remarks. Thank you. At this time, we'll go ahead and close the hearing on SB 115. And we will go ahead and move on to the next bill. I'm going to give Senator Chris Crawford just a little break. And at this time, I'm going to go ahead and open the hearing on SB 177. Senator Orenshaw, when you're ready, you may approach. I'll also note there is a conceptual amendment for 177 that has been posted on Nellis.
Good afternoon, Chair Torres Fawcett, members of the committee. For the record, James Orenshaw, I represent State Senate District 21 down in Southern Nevada. Thank you very much for hearing Senate Bill 177 today. With me to help walk through the bill, I'm very lucky to have Jonathan Norman with me to my right. He's the statewide advocacy, outreach, and policy director at the Legal Aid Center of Southern Nevada. Down in Las Vegas, I have Marina Dahlia Hunt. She is the team lead for the educational advocacy program.
Senator, I'm not sure that I can have two dahlias in one.
Marina,
But for today, we'll make an exception.
Thank you very much for your indulgence, Chair. She is the team lead for the educational advocacy program at the Legal Aid Center of Southern Nevada. Also, I'm very fortunate to have Ilka Fisher, who is a lead advocate in the education advocacy program at the Legal Aid Center of Southern Nevada. In my work life, my day job, I'm a children's attorney. I'm a public defender in juvenile court. And many of the children I represent who have been arrested, been accused of committing a delinquent act. Many are children who have been in foster care or who have been homeless or who are homeless or who are currently in foster care. And one thing I've learned from being a children's attorney and working with these kids is that so many of the children I've represented have had so many traumatic and toxic events happen in their life. They have had a parent that's been killed, incarcerated, or is gone for other reasons. They have had homelessness. They've had so much instability. And I'm not saying that forgives disciplinary problems in school, but I believe it needs to be taken into account. I think Senate Bill 177 and the conceptual amendment strikes a good balance of trying to help these vulnerable children. With your indulgence, Chair, I'd like to turn it over to Mr. Norman, Ms. Dahlia Hunt, and Ms. Fisher, and then I'm happy to stand for any questions.
Chair, members of the committee, Jonathan Norman, NORMAN with the Nevada Coalition of Legal Service Providers. I'll just say a few remarks about the education advocacy program. So at Legal Aid Center, we represent over 3,000 kids in foster care with direct representation. And along the way, we've noticed that there are a lot of school issues, whether that's getting the right IEP, making sure that discipline problems, that kids are getting as many days in school as they can. So we started our education advocacy program, which first only dealt with foster kids. Now we also take community referrals. And with that, I'm going to turn it over to the team in the South to do remarks and run through the bill. Thank you.
Good afternoon, Marina Dahlia Hunt for the record, MARINADALIA-HUNT. So both a Dahlia and a Hunt. I am the team chief of the Education Advocacy Program at Legal Aid Center of Southern Nevada. As Mr. Norman mentioned, we are housed within the Children's Attorneys Project, which represents essentially all children in dependency and guardianship proceedings down in Clark County. And as a unit within the Children's Attorneys Project, we represent the educational decision makers of hundreds of children in foster care, both in the context of special education and school discipline. In the last decade, this legislature has made great strides forward in protecting the educational rights and recognizing the unique educational needs of children in foster care, including by mandating the appointment of an educational decision maker for all children in the foster care system. In 2021, this body made an additional stride forward in recognizing and protecting the unique educational needs of children in foster care through SB 354, which added in a provision that a homeless or foster student could not be expelled from school or suspended for more than 10 days unless a determination was made that the behavior that led to the consideration for suspension or expulsion was not caused by homelessness or being in foster care. The person responsible for that determination was required to presume that the behavior was caused by homelessness or being in foster care. The following session, that presumption was reversed so that the school must presume that whatever the behavior was not a manifestation of the student's foster care or homelessness status. When a child is removed from their family and placed in foster care, they lose access to almost every part of their life. The one exception for many children might be their school of origin. Yet a child who has, for example, been sexually assaulted by a relative or horrifically physically abused is often expected to go to school the next day after removal and behave like any other student. This is simply not possible for some students. To recognize that children in foster care come to school with multiple layers of trauma that affect their still developing brains, the legislature in 2021 codified that a student's adverse behavior at school should be presumed a manifestation of their being in foster care. To determine whether the behavior was a manifestation of the student being in care, the person responsible for making that decision was required to consult only with the school counselor or social worker, not with the student's EDM. Despite this omission, this was a good law that balanced schools' need for safety with the unique needs of children in foster care. Academic success for children in foster care, particularly students of color and students with disabilities, is extremely low. Nevada currently has significantly worse outcomes for children in care than the national average. This year, less than half of Nevada's 12th grade foster students are going to graduate from high school. These numbers drop to about a third for students in foster care with IEPs. Despite these statistics, as I mentioned, in 2023, the legislature reversed the presumption against children in foster care, providing that instead of the student's behavior presumptively being due to their being in foster care, the presumption was that it was presumptively not a factor under AB 285. This change was made in connection with sweeping reforms related to school discipline for all students and did not seem to include any conversations about the unique needs of students in foster care. Unfortunately, this switch has had negative impacts on children in care, who already have the odds stacked against them. In conversations with stakeholders, namely the school districts across the state, the new law dispenses with the presumption altogether and instead follows the exact same model as the Individuals with Disabilities in Education Act, the IDEA, and simply mandates a meeting between the school and court-appointed educational decision maker, which can be the parent, when a school seeks to suspend a student in foster care for a lengthy amount of time or expel the student. Second, at that meeting, the team must determine, with information from the educational decision maker and other team members, whether the behavior in question was due or substantially related to the child being in foster care or being homeless. If so, in most circumstances, the discipline must cease, and instead, appropriate supports must be put in place to address the child's unique needs. If it was not a manifestation, regular disciplinary practices apply. And per the conceptual amendment, if the student committed a serious infraction, which includes bringing a weapon to school, bringing drugs to school, or committing bodily injury to staff or peers, the student may still be removed for up to 45 days from school, exactly the same as for children with IEPs. I'd now like to briefly walk through the bill which incorporates the conceptual amendment filed yesterday. So first, Section 1 would be deleted by amendment except for the addition of definitions for battery, bodily injury, dangerous weapon, firearm, and foster care. Section 1.5 would mandate a meeting to determine if the student's homelessness or placement in foster care was a factor in the student's behavior. For foster students, this meeting must include the student's court-appointed educational decision maker. For homeless students, this meeting must include the local education agency's liaison for homeless students. Section 2 would mandate that a homeless pupil or pupil in foster care could not be suspended for more than 5 days or expelled from school if after a meeting between the educational decision maker and school, the team determines that the behavior was due to that status. Prior to the meeting, the principal must review the student's cumulative record and academic plan, interview staff, and consider other information provided at the meeting. If the behavior is found to be a manifestation of the student's status, all discipline must cease and proper supports must be put in place. With the conceptual amendment, subsection 15C would provide that regardless of a student's status as being in foster care or being homeless, a principal may remove a student for up to 45 days to a behavior school if the student was found in possession of a weapon or drugs or caused serious bodily injury on campus. Section 3 applies these same protocols for children under 11 who are homeless or in foster care, but does not include this exception for the weapons, drugs, or injury. Section 4 designates that this law takes effect on July 1st. I will now turn this over to my colleague, Ilka Fisher, who will explain the need for these revisions through some recent case examples.
For the record, Ilka Fisher, ILKAFISHER. I'm the lead advocate for the Education Advocacy Program at Legal Aid Center of Southern Nevada. I have served as an advocate in this role and in this program for over 10 years, and I also run our Volunteer Education Advocate Program, which matches volunteers to the highest needs kids in foster care to serve as their educational advocates. Children in foster care have unique educational needs. These needs can span from undiagnosed disabilities due to educational neglect to trauma-related disorders due to abuse in the home. Every child processes the trauma that resulted in their removal differently. What happens when an educational surrogate is not present in the room when discussing a child's conduct is that the school team, who are devoted professionals who are generally champions for the child, misses the whole story. When I started in the Education Advocacy Program, there was no unique protections for children in foster care. When SB 354 passed in 2021, we saw improvements in the understanding of children in foster care. After disciplinary issues, we were able to come together as a team to discuss creative solutions. One such example of how this process can work to protect kids is Aaliyah. Aaliyah was a student at a CCSD high school who was placed at Child Haven, the temporary shelter for children in foster care before they are placed in a foster home or back with their relatives. Like many children in Child Haven, Aaliyah's entire life's belongings were contained in her backpack. This is very typical for children who are removed from their families and are told to put everything they need in a backpack to leave the home. One day, Aaliyah got caught in a tardy sweep. As part of the sweep, the student confiscated the students' backpacks. Aaliyah was unwilling to surrender her backpack, which contained everything she owned in the entire world. The staff insisted, and she got physical with the staff. This was a staff member who, unbeknownst to them, was trying to take away the only possession this child had over a tardy. Because the school had an SB 354 meeting and included members of this child's team, they were able to hear Aaliyah's full story and immediately reversed the expulsion. Because she was not expelled from high school, Aaliyah ultimately earned her diploma and is now in nursing school. This would not have happened if she had been expelled over a backpack. After the law changed in 2023, the school district was largely chaotic. School staff was left without clear guidance on what was supposed to happen when a student in foster care was subject to expulsion proceedings. Some schools were still learning about SB 354 and then suddenly were instead subject to the reverse presumption. Schools did not know who was required to attend a meeting about an expulsion or if one was even necessary. This uncertainty unsurprisingly hurt kids. Tiara was removed from her mother's care after her and her siblings were beaten by her mother with an extension cord. Very soon after coming into foster care, she was pursued in the hallway by a male student who repeatedly harassed her by calling her the N-word. Prior to coming into care, she had been harassed by this same male student. She tried to separate herself from the student, but he kept following her. Staff did not intervene to stop the boy, but did intervene when Tiara felt so threatened she pushed the boy away. Triggered by a staff member holding her body, she fought back against him. She was then expelled for battery on staff. The team refused to consider the circumstances of her entering care only a few weeks earlier when making that decision. Right now, the system is chaotic. It is unclear who is supposed to be involved in the conversation about expelling a student in care or what is supposed to be considered. Children who are entering foster care lose their homes, they lose access to their families, they have experienced physical or sexual abuse, they have lived with parents in domestic violence relationships, parents who are abusing drugs, or have untreated mental health issues. They themselves may have disabilities that have never been addressed by their parents. They then enter a system where they face an endless rotation of caseworkers, placements, and other adults coming into their lives, and they are expected to go to school the next day and behave like any other student. While some children are miraculously able to do this, others struggle. To address this turmoil, the legislature created a system requiring that each child receive some stability in their education by requiring the appointment of an educational decision maker for every child in foster care. Ensuring both that the school considers the series of traumas and loss a child in foster care has experienced and includes the person most knowledgeable about their history as it relates to education, their court-appointed educational decision maker, will help some of the most vulnerable students in the school system succeed. We welcome your questions.
And this is Jonathan Norman. For the record, I did want to just mention, so in foster care, we use the term educational decision maker. So that's just who's making decisions for the kid, and the court will appoint that person. The presumption in the law is that it's supposed to be the parent. And if the parent is unable or unwilling, then there's kind of a priority list. So you would look at who's on that list. It could be another relative. It could be the foster parent, that the child's in their home. And then for all the cases where there is no one from that list, there's the volunteer education advocacy program, which is typically like a CASA or somebody from the community who is background checked and trained by our office and serves as a volunteer, stepping into the shoes of the parent for those educational decisions. And so I wanted to make sure that, we used that term, and then wanted to make sure everybody understood it. And then second, we did, in conversations today, too, ideas came up that I think make a lot of sense. One is making sure that schools aren't held responsible if they don't know that the child is homeless or if they don't know that the child is in foster care. So I anticipate having another amendment to make sure we're not coming, a month after this happens and saying you should have known, right, that the kid was in foster care. So making sure that there is a limitation there, and then also making sure that there's a limitation to the number of efforts a school has to make to have that meeting. Under IDEA, I think there has to be 3 efforts, and then the meeting is held without that educational decision maker. I think those make a lot of sense, so I would anticipate having another amendment to reflect those ideas. And we're ready for questions. Thank you.
And I'm sorry, could you state those points that you were still looking at for review just one last time so I can make sure I have them copied correctly? Thank you.
Yeah, Jonathan Norman for the record. The 2 things, one is making sure that we're not holding the school responsible if they don't know that the child is homeless or if they don't know that the child is in foster care. So, kind of limiting that so there's not some, a school administrator getting in trouble for not having this meeting when they had no idea the youth was a foster child or was a homeless youth. So that's 1. And then 2, when you have a meeting under IDEA, the school makes 3 efforts to contact that decision maker. So if they've made 3 efforts and the decision maker hasn't been reached, then the meeting would proceed and the principal would make that assessment without that education decision maker present. And that way it's not one, just like never ending, how many contacts should you have to make? And 2, if they do hold that meeting without that education decision maker, that they don't somehow get in trouble for that later.
Thank you. And just to kind of follow up on that before we get into the other members' questions, but just for that point, for the limitation of efforts to reach out, there would also need to be a change on when that meeting would take place, because right now it says it would occur on the 6th day, or it's very much prescribed. So there would have to be some reconsideration for when that meeting would take place, because I can reach out in 3 different ways on one day. But that might not necessarily be the most fair process for that. At this time, members, I'll take any questions. Assemblymember Mosca.
Thank you so much for this important bill. May is National Foster Care Month, so I think it's really important we're hearing it now. And, as a foster care parent, I really appreciate this bill. My question really is why, or do you know if it was not included in last session's bill on purpose, or was it just an oversight?
Jonathan Norman for the record. I don't know if it was an oversight or included, or if those discussions were just global. I do think that, one thing I think in working through this bill this session that we've been intentional about is not undoing something from last session, right? So the law prior to last session was that there was a presumption that the behavior was related to their status as a foster child. We understand that we don't just undo laws right away, right? They were put in place with agreements with stakeholders. And so we didn't, initially I think we had it where the presumption would be switched back to that. And then as we've navigated it, we've understood that we shouldn't just be undoing something right away. And in talking with the school districts, getting rid of that presumption and following a more IDEA framework is something that still provides the meeting, which is what we think is most important, but also doesn't put schools in a position where they have this presumption that, frankly, they didn't feel like they could ever overcome it. So they couldn't institute discipline. And then, Chair, to your comment, I think that was right. We have to change the timing of that meeting.
Thank you. You did 2 in 1 quick response. Great job. Members, any questions? Assemblymember Lewer Hatch.
Thank you so much, Chair. Thank you for being here and for really advocating for some of our most vulnerable kiddos. And as a teacher, I appreciate that. As a teacher, I know that we need to balance the rights and the needs of those students that are going through trauma and that have severe issues, but also with the safety of the 35 other kiddos that are in my room. And so I wondered if you could just speak to that safety element. I noticed with taking out the presumption, we're going to have a discussion about whether this relates to homelessness or being in foster care. From the examples you shared, it sounds like it pretty much is always going to relate to the situation they are in. And so looking at the amendment, it says we can really only remove them if they're causing severe bodily harm. In talking to my administrators over the years, they've always interpreted severe bodily harm as permanent maiming. And that seems a little extreme to me. And so I wondered if you could just speak to how we're balancing the safety aspect.
Jonathan Norman, for the record. I'll take part of that question and then send it to Marina for the rest of the question. I think that, in the bill, the principal or the administrator is going to make the ultimate call as to whether that status relates to. So I think they, because the presumption's not working either way, in the examples we gave, I think those are definitely related to the status of the child. But and maybe Marina can talk because she's working in this space directly, but I feel like it will give the flexibility for the administrator to strike that balance. Marina?
Thank you. Marina Dahlia Hunt for the record. So just a couple of things, and this comes up a lot even under the current system now, where there actually is no 45-day exception. So technically under the law right now, regardless of the student's behavior, if it's found to be a manifestation of their being in foster care, there's no 45-day they can go to behavior school. So this actually adds a layer or another tool for schools under appropriate circumstances. But what I would say for those kind of less horrific injuries is we still have very robust restorative justice practices and rights for victims in classrooms. So what the meeting then prompts at the current time, and what we would hope would continue, is a conversation not just about the needs of the student, how we can better support the unique needs of the student, but also keep everyone safe. So if a victim is on campus, has been harassed by, say, a foster student, they still have a right to be safe at school. So we talk a lot about administrative moves to make sure that everybody's safe. We institute behavior contracts, no contact orders. All of that in requiring a meeting actually gives everyone a forum to make sure that we can balance all of the rights of everybody in the classroom, not just that of the foster student, to better serve everybody.
Thank you, Chair, for letting me have a second question. So I appreciate that, and I think that we've had a lot of debates about restorative discipline and expulsion and suspension, and all of last session we did. And I think that a couple of your presenters spoke to this, of there seems to be kind of a pendulum of a backlash, and there's confusion in the schools of what are the rules and what are we following. And so I just wonder, what is your plan, or how do you think this will impact if we just changed things last session, now we're changing them again, how will that add to or compound, or maybe it won't, impact the confusion that we're seeing in schools regarding discipline?
Jonathan Norman, for the record. I do think, there's a challenge in rolling out any policy to so many schools that, operate somewhat independently from the school district. And I recognize that challenge. I think for this, it is a discrete number of kids. So in, Clark County, we have, I don't even know, 3,900 kids or 3,600 kids in the school district. And then in foster care, we have anywhere from 3,000 to 3,600 kids, not all of school age. So some are, under the age. So I think it's a smaller number. And I do think, and Marina can speak to this, that in Clark County, the team that we deal with a lot, once we're engaged and they know that the child is a foster child, actually they do a really great job once they're looped in. So I think it will be incumbent upon, kind of a partnership between us, Clark County Social Services, and the school team. I think it's led by Dr. Holloway, to make sure that those are rolled out. And some of it we'll be learning as we go, right? Schools, whether it gets pushed down from the administration, a lot of times if we're interfacing with a school and it's the first time they've dealt with that situation, we just learn together, and we hope those meetings allow that collaboration. And then that's how that, I think, will practically work. And Marina, I don't know if you have anything else.
Yes, thank you. Marina Dahlia Hunt for the record. So I would say first, just kind of anecdotally, and Mr. Norman is right, that down in Clark County, we have a fantastic foster care department that is very focused on meeting the needs of every student in the classroom, including foster students, when these discipline issues come up. So I would say, just again, anecdotally, some schools don't, I mean, within the last couple weeks, we've had schools indicate that they did not know there was this additional protection back from SB 354 for students in care. So there's always going to be a learning curve, as Mr. Norman mentioned, but we've been very intentional in this, especially through the amended version that's now before us, in grafting onto the IDEA framework, because that is a framework that schools already know through the manifestation determination review. The language is identical. So it's not teaching them something new, it's just adding in an additional group of students for which this process applies. And then I would also say that when we have these meetings with schools and we're brainstorming best supports for the student, we provide, unique community context that we've developed. One example is the impact program that the schools are excited to learn about, and that can extend to other students outside of the foster care system. So it really pulls everybody up when we have these meetings to better support one group of students. It then helps us support all students with disciplinary issues.
Assemblymember Hanson.
Thank you, Chair. Thank you for being here. And first of all, you two gentlemen are some of the greatest humans I know, doing great work for kids. But we're trying to find this balance, as my colleague mentioned, and I appreciate the amendment. But I do have a question in regards to the 45 days found in Section 2, Sub C of the amendment. So if you hit the not more than 45 days, what is our measurement if a child in these circumstances is placed elsewhere due to battery or dangerous weapons, that sort of thing? What does it look like to integrate them back in when the 45 days are up, if I'm reading that correctly?
Ilka Fisher for the record. So normally what we do is we have been focusing a lot on transition planning. And so we're talking about making sure that this student has a plan prior to returning to school. So we make sure to include any administrators, staff, and then we want to make sure to include everybody at the school level who's going to be involved with the student in creating this safety plan for the student's return, and then everybody outside of the school as well. So that would be the child's attorney, any sort of educational decision maker or advocates that are involved in the case, as well as the caseworker and anybody, like I said, that's involved. So that could include outside providers. For example, I had a meeting yesterday where we brought in the outside ABA therapist. We brought in their actual individual therapists who addresses the mental health side of things. And we came together as a team and we talked about a safety transition plan for the student to return back to school.
Thank you, Chair. So, but what if the student is not exhibiting behavior that would be conducive to being back in the setting they had been removed from? If the child is just still being very aggressive, not seeming to want to work through this, is the 45 days absolutely definitive and we have to? I'm just caught up a little bit on the 45 day as a marker.
So Marina Dahlia Hunt for the record. Sure. So first, again, the 45 days is from the protections under the IDEA for students with disabilities as well. So first, I would say all students in foster care are required to have an academic plan, which is meant to identify their needs and what needs are unmet. I would say a student who is exhibiting such extreme behaviors that they are unsafe to be in a comprehensive campus, that under the Individuals with Disabilities in Education Act is probably prompting the need for an IEP evaluation to ensure that they're in the appropriate school setting. So we have students who have habitual disciplinary issues. We work with a lot of them. They often end up needing to be institutionalized at residential treatment centers where their mental health is the primary focus for a while, with school still going on kind of in between therapy. We then have a step down program to a partial hospitalization program where they kind of do schoolwork on the side. And then I'm missing one of them, the part after PHP, IOP, yeah, which would be after school, they also receive intensive therapy. So I would say the meeting portion gets everyone together to better bring all the service providers together and brainstorm. If a student is exhibiting such extreme behaviors that it's not safe for them to return to school, I think that's a bigger problem about unmet mental health needs and additional academic and educational needs for that student.
And Jonathan Norman, for the record, I think also we could look at, when we talk about that, the 45 days, having, instead of a hard 45 days where it's come back, is assessing whether that child can be safely returned to that campus and maybe putting in that plan. And I think that's consistent with the current law where you have expulsions, and then when, it's not quite definitive in the current law, when you're having that planning to reintegrate that child back into, a normal campus. I think maybe we could set, instead of having a 45-day hard cut, we could have a day where that student has to be evaluated for whether they can appropriately be reintegrated into campus, and having those meetings. That way, if you do have the instance where a kid is clearly not safe, in that meeting, you could trigger the IEP evaluation if the student doesn't have an IEP, or you could say, here's the supports we can put in place to bring this kid back into our campus. And then if it's not safe in a residential treatment center, you can make that evaluation there. And so I think we would be open. I'd have to talk to our team offline to having that triggering a meeting to talk about the child's return to campus instead of a hard cut, which is how it appears in the amendment. So I appreciate that.
And Chair, with your permission, James Ornshaw, State Senate District 21. Just from my anecdotal experience with children I've represented who have been sent to behavior school away from their normal school, usually the kids I represent, their number one goal is to try to get back to normal school. Not only because they've been separated from their friends, but in most cases the behavioral school won't have some of the extracurricular activities, sports, things like dances, proms, things that, part of normal teenage life. So does that mean every kid who gets sent to behavior school is going to succeed and make it back to their normal school? Not necessarily, but that's certainly my anecdotal experience with the children I've represented in, delinquency proceedings who've been sent to behavioral school. And so I just wanted to offer that as well. And Chair, I wonder if I could ask your indulgence. I'm supposed to go gavel in Senate Legislative Operations and Elections downstairs. Would it be all right if I be excused and I allow the team to
definitely.
try to... Well,
Yeah,
thank
not
you
a
for hearing
problem.
the bill. Just they're sending me text to go down and gavel in and start in. But if I'm needed, I can turn the gavel over to the Vice Chair and come back up if
I think we should be good. I think the team here has your back, but if there's any questions, I'll make sure to reach out to you directly as well.
Thank you very much for hearing the bill. Thank you, committee. And sorry, I have to run.
Thank you. I did have another question. If you could just explain and kind of walk me through the process. If a student is foster or homeless youth, does something that would have either, I want to know both scenarios. So they have less than a 5-day suspension or more than a 5-day suspension. Can you walk me through what that looks like? Like this happens first, this happens second, this is when the meeting would occur. I just want to make sure that I understand it very clearly.
Marina?
Yes. So Marina Dahlia Hunt for the record. So for under 5 days, the process is just the same as any other student. So generally so just using an example of, I don't know, what's the standard one we see? Like a fight, like a student's in a fight, they're young, say they're like a 6th grader, so they're 12 years old. They would be put on RPC status, which is required parent contact, until they could return to school. There'd then be a little conference between generally the student, the educational decision maker, maybe the caseworker and placement, and then they would just return to school like any other student. When a student is say pending expulsion. So a standard one that we see is bringing a marijuana vape to school. And say it's like the third time this has happened and they want to expel the student. So they would be, and say they were even criminally charged for possession of marijuana. They would be put on basically RPC status, the same exact thing, but then instead of them returning to school, they would then get a notice of suspension pending expulsion. In that time period, then the notice would go out to the educational decision maker, who should have already been informed under the law of all of these steps that have already taken place, that a meeting is going to be held between the school and the educational decision maker on the expulsion. So when a student doesn't have an IEP or isn't in foster care, the regular path would be if the parent wants to contest the expulsion, they then speak to the principal. It's then elevated to kind of an administrative process and then a hearing panel, right? So that still goes on for students in foster care. But separately, there's another meeting that takes place where the educational decision maker can invite whomever they would like. So that might be the children's attorney, that might be the caseworker, the placement. We've seen ABA providers attend, therapists attend, to just provide more information to the school team. Generally, the school team is made up of a couple of teachers and then an admin, just like in a manifestation determination review, where it would be kind of an admin, a general education teacher, and a special education teacher. It's very similar on the foster care side. They would then have a meeting to discuss the incident and review additional information that is provided by service professionals and individuals who know the student. After that, the school team would then meet privately to discuss what has happened. And if they agree that it's a manifestation of the student's disability, the discipline will be stopped. If they, or excuse me, not disability, of their being in foster care, the discipline will be stopped. The packet, we call it an expulsion packet down here, will be taken back, and the student can return to school. We try very hard, especially for these kind of trickier cases, to have transition meetings back to school, because we don't want the student to just go back to school having had this disciplinary issue and then immediately do the same thing over and over again. So that is an opportunity to do things like amend the behavior improvement plan, otherwise known as a BIP, to look at doing a functional behavior assessment to see if we can notice common trends that are prompting these outbursts or disciplinary issues. Sometimes, actually quite often this year, we talk about moving the student to a different school because there might be additional factors going on at the school that are causing these ongoing disciplinary issues. Sorry, that was quite a long answer, but that's kind of how the process would play out.
Thank you. I'm going to go to Assemblymember Flanagan.
Thank you, Madam Chair. Thank you for the presentation. My question has to do with, so we're talking about foster care kids, homeless kids. Are they categorically identified, like on the way in, to say this is a foster care kid or a kid that may be homeless, to track them? Or is this bill identifying at the point that they begin to have a problem more leniency in disciplining this child or these children?
Jonathan Norman.
Sorry.
You go.
Sorry, John. Marina Dahlia Hunt for the record. So they are identified in the online system Infinite Campus at the time of enrollment or when they are removed if it's during the school year. So the Department of Family Services will provide a placement letter to indicate that the student has been placed in foster care. That will then be flagged on the online system. The school will also be provided with a copy of the order appointing the educational decision maker so that that individual can be identified within the system as well, so they know for communication. So generally speaking, there always are, administrative errors, but generally speaking, all foster students are known to the school district at the time of their removal or very shortly thereafter.
Madam Chair, may I have a quick follow-up to that then? Are they then tracked for special support to assist with them not reaching this point as opposed to responding to it? I just want to make sure we're not looking at I'm not saying it's not necessary, but a reactionary step as opposed to one where we could be more proactive.
Ilka Fisher for the record. Yes, so when a student is placed in foster care, they're supposed to have an academic plan completed at the school level. If the student doesn't have an IEP or a 504 plan, that academic plan should be immediately completed. And then through that, they can also have a functional behavioral assessment and a behavior intervention plan created through that academic plan. And then if the student needs additional supports, then we look into possibly a 504 plan or an individualized education plan. If we need special education supports.
Assembly Member Hanson.
Thank you for another chance here, Chair. Appreciate it. I'm waiting to get a little phone from a friend over there with our legal eagle. There is a reporting requirement as part of AB 285 from 2023. Now, some of that bill, the effective date is like 2028 for the framework, and I'm just looking to see what the reporting effective dates were. Wondering if you have or will use that reporting data that is required of that bill, that a principal report any of these incidents August 1st, any kids that have been suspended, expelled, that sort of thing. Are you looking to utilize some of that information and helping you see how are these kids categorized as homeless or foster as part of that reporting? You might not know that though, so it might just be more rhetorical.
Jonathan Norman for the record. I would have to go back and look at that. I do know that I feel like that those reports are forthcoming because I've seen, because it's based on disproportionality of discipline based on different categories. So I think we would definitely engage that data. And, you know, as a backdrop, even though we're attorneys, right, we're legal aid, we're not suing the school district for money or trying to get anything. We usually are trying to get services, and that's it. And we work very collaboratively with the school districts and view them as partners, not adversarial. But yes, we are looking forward to that data. And also I know there's efforts with the Nevada Department of Education to be able to pull data directly from Infinite Campus so that it's not causing the districts to have to like parse out, like the RPC was mentioned, and you know, I feel Clark County wasn't reporting that as a suspension, even though that's what it is. And so I think there'll be a time in the next few years when the Nevada Department of Ed is able to pull that data directly from Infinite Campus, which will be great.
Thank you for that. Our legal, thank you, Mr. Killian, was able to say that it did become effective July 1st, 2023, that the reporting requirements would take effect. So I would think that we could look for 2024 school year that we would have some data because it would have been reported for that. It'd be interesting to just see if we have some homeless and foster children that are falling into that category of suspension, expulsion. So thank you, though. I appreciate it.
Thank you, Assemblymember Orlicker.
Thank you, Chair, and thank you for the team for all of your work on this bill. My question is about the amendment and the exception, the group of exceptions in 2.15C. So having a dangerous weapon or causing substantial bodily harm make a lot of sense. I'm wondering about the student who's knowingly possessing a controlled substance. There's quite a range of controlled substances. People with mental health issues self-medicate with controlled substances. So it seems out of place in this list of exceptional circumstances. Could you speak to that, please?
I'll take it. Raina Dahlia Hunt for the record. So again, this is directly from the IDEA, and this was something that the school districts were very concerned about. I would say just anecdotally, a lot of students do self-medicate with especially marijuana, and it is a different situation than, for example, bringing a gun to campus, but this was something that was very important to the school districts.
Thank you. And if I remember correctly, it was one of these past legislative sessions. I can't remember which one because we've done a lot of work on restorative justice since 2019. But I know that we have just given permissive language for school leaders to expel if necessary, but it's not required. So ultimately, it would still be my understanding is that with this legislation, it would still be at the leisure of the administrator to make the decision necessary for their campus. Is that correct?
Jonathan Norman, for the record, yes, that's still in the provisions.
Thank you. I appreciate it. Just because, obviously a student that maybe brings gummies to school that one day, that student maybe wouldn't be expelled. But students that are distributing, fentanyl, that would obviously be an expulsion, right? So they're treated differently. At this time, members, do I have any other questions? It doesn't appear there's any additional questions at this time. Thank you. Thank you for presenting. We're one Dahlia down, but I'm happy we were able to fill his place today. He's out presenting another bill, but he does send his warm regards. He wanted that to be clear for the record. At this time, I'll go ahead and invite anyone wishing to testify in support for SB 177.
Good afternoon, Chair, members of the Education Committee. My name is Alex Ortiz, Alexortiz. I'm here representing Clark County, and by including the first of all, we do support SB 177, and want to say that by including the educational decision makers for foster children and advocates for pupils in foster care when making disciplinary decisions, a more informed decision will be made that better considers experiences and well-beings of foster children in school settings. So we do appreciate Senator Orenshaw bringing this bill forward that we believe will help the children in the foster care system. Thank you.
Thank you, and thank you for coming out of nowhere to represent Clark County. For those of you that don't know, he used to be in this building all of the time. So welcome back. It's good to see you.
Madam Chair, members of the committee, my name is Susan Kima. I represent the Nevada Association of School Superintendents, and we are support of SB 177. I would like to add that we liked the way the discussion was going around that 45 days, and if there's going to be an amendment, superintendents would like to be part of that discussion. Thank you.
I don't see anyone else wishing to testify in support here in Carson City. Do I have anyone in Las Vegas wishing to testify in support of SB 177? Seeing none, AVH, I'll go to the line.
If you would like to testify in support of Senate Bill 177, please press star 9 now to join the queue. Chair, there are no callers choosing to testify at this time.
At this time, we'll go ahead and go to opposition. Is there anyone here in Carson City or in Las Vegas wishing to testify in opposition to SB 177? Seeing none, AVH will go to the lines.
To provide testimony in opposition to Senate Bill 177, please press star 9 to join the queue. Chair, there are no callers choosing to testify at this time.
Thank you. At this time, we'll go ahead and go to neutral. Is there anyone here in Carson City or in Las Vegas wishing to testify in neutral? Seeing none, AVH will go to the lines. Is there anyone wishing to testify in neutral to SB 177?
If you would like to testify in neutral for SB 177, please press star 9 to join the queue. Chair, there are no callers choosing to testify.
Thank you. At this time, it moves so fast. I almost forgot where we were in the line. At this time, I'll invite the bill sponsors for any closing remarks. I think Mr. Norman, are we good on closing remarks? All right, we're good. So at this time, we're going to go ahead and close the hearing on SB 177. 1 minute recess. The Assembly Committee on Education, the most studious committee in the Nevada State Legislature, will reconvene. At this time, we'll go ahead and open the hearing on SB 27. If I have not already, I am closing the hearing on SB 177 if I failed to do that previously. And I will open the hearing on SB 278. The senator is very ready and very eager to present this bill. So when you're ready, please begin.
Thank you so much, Chair and Committee, for welcoming me back. Love customs and courtesies as a freshman here. Senator, I get to learn all the things by doing it wrong and being told to do it correctly. My name is Shelley Cruz Crawford. For the record, I am the Senator for Senate District 1 in North Las Vegas. I am really excited to present 278. It came out of years of work that I've been doing as on the Principal Advisory Cabinet for the state, where we meet with principals in charter, public, and private schools to come together to solve big problems in education in the state of Nevada. And I'm on the Teacher Recruitment Retention Task Force. So this was a big bill. It was focused on recruitment, retention, and promotion into leadership positions. It's been drilled down a lot because what I've learned is when you are a legislator, when you put things in the bill, it freaks people out and they fix it on their own. So we are going to move on to some just really clean up licensing pieces of this bill. I do have Jeff Brisky from the Nevada Department of Education in Southern Nevada to discuss this more. But basically, two parts of the bill, or answer questions as needed. Jeff Brisky's here. Jeff, don't worry, you don't have a presentation. The two parts of this bill do two things. It's really directing the Department of Education to clean up some of their licensing requirements. I'll give you one example that we have various ARL license programs, and while people are going through those programs, a lot of times they shift where they're going in that, and if they're pigeonholed in a program, they can't stack provisional licenses. I would never make a law based on one antecedent event. I am a researcher. I have my doctorate in organizational leadership, but I can share one example from my school. I had someone going through this licensing program, ARL, and they were teaching fourth grade. Unfortunately, I had to compact that classroom, close it, and they wanted to stay at our school. And all I had left was a special ed classroom. And they said, could I go there? So I said, great, go over there. And as I tried to move them over in HR, they said, no, they already have their provisional in general ed K through 8, so they can't do their provisional and special ed. I'm like, well, they're already in the program of study and they can shift at this time. So this is really directing the Department of Ed to streamline and clean up some of those licensing. It doesn't lower the bar. Same requirements exist. And then the second part of this bill is Read by 3 is a great program that we have that provides in most schools a strategist that coaches teachers on literacy programs, teaches side by side with them, and also pools students for small group. This is clarifying that districts, once students are proficient in reading, that they don't need to work directly with those students. So we can focus those resources on the students that are not proficient in reading. So I'm going to turn this over to my intern, Brandon Michelle. He's going to read through the portions of the bill, and then Jeff Brisky will be available down south for any questions.
Brandon Michelle, for the record. In an effort to remove barriers to licensure and help improve our pipeline of educational personnel, Section 1.1 of SB 278 requires the Commission on Professional Standards in Education to consider and adopt regulations that improve access to the licensure and endorsement of educational personnel. These improvements include, but are not limited to, changes to streamline procedures, consolidate requirements, or otherwise simplify and improve the process for those enrolled in an alternative route to licensure program, or those who have completed the education or training for licensure through such a program. Turning to the literacy proficiency sections 2.6 and 3, eliminate the use of local assessments in determining a pupil's reading deficiency. The state assessments will still be allowed to for this purpose. Section 3 also removes the requirement for school districts and charter schools governing bodies to report on pupils receiving intervention services and instruction for such deficiencies. Additionally, Section 2.2 prohibits any entity other than the State Board of Education from requiring public schools, school districts, or charter schools to report on related information. Finally, Section 3 of SB 278 provides that a pupil who is no longer deficient in reading based on a statewide assessment results is not required to continue receiving related services or instruction.
Thank you so much, Shelley Cruz Crawford. For the record, I did want to let you know that I sat down with the Nevada Department of Education, formerly State Superintendent Joan Ebert, and we went across all the districts and rurals to show what the Read by 3 reporting was. And what we found is that it was different, and some asked way beyond what the state required. This was reported to create teacher burnout through my work for teacher recruitment and retention, and we wanted to not overburden teachers with additional paperwork that they're not using to guide instruction. So this just reduces districts from asking above and beyond that reporting source, and I did work with the districts for that. Thank you.
At this time, do you have any questions from the members? Questions? Okay, seeing no questions, we'll start with our support testimony. Is anybody in Carson City in support of SB 278?
Good afternoon, Susan Kima for the record, K-E-E-M-A. I represent the Nevada Association of School Superintendents, and we are in support of 278. The proposed elements of 278 fall within the learning goals of our districts. Thank you.
Good afternoon, Mr. Vice Chair and members of the committee, the most studious committee. As a former teacher, I very much like your appellation there. My name is Sarah Adler. I represent the Charter Coalition of Northern Nevada, who are pleased to rise in support of SB 278. As you all know, there are multiple pathways to teacher licensure. One of them is for schools to grow their own teachers from paraprofessional on through fully qualified teachers. A recent experience one of our charter schools had brought to light frustration in the process of getting licensure for a recently naturalized citizen. This individual, this gentleman, simply did not have the documentation of his name change that was on the licensure office's prescribed list. And we were able to work with Deputy Superintendent McGill and with Mr. Jeff Fricky, I believe his name is. We appreciate that. But the intent of this bill to get at these various paths to licensure and get those sorted out, I think will be very helpful as we go forward. And then our schools would simply like to add a big round of applause for streamlining the reporting. Thank you very much.
Good afternoon, Chair Torres Fawcett, Vice Chair De Silva, members of the committee. My name is Wesley Harper. I am the Director of Government Affairs for the City of North Las Vegas. This is a bill that strengthens the education system and benefits our residents, and therefore the city is in support. Thank you.
Seeing no one else here in Carson City nor in Las Vegas at this time, maybe H will go to the line. Is there anyone wishing to testify in support of SB 278?
Thank you, Chair. If you would like to testify in support of Senate Bill 278, please press star 9 to join the queue. Chair, there are no callers choosing to testify.
At this time, we'll go ahead and go to opposition. Is there anyone wishing to testify in opposition to SB 278? Seeing none in Carson or in Las Vegas, AVH, is there anyone on the line wishing to testify in opposition to SB 278?
To provide testimony in opposition to Senate Bill 278, please press star 9 to join the queue. Chair, there are no callers choosing to testify at this time.
Thank you. At this time, I'll go ahead and go to neutral. Is there anyone here in Carson City or in Las Vegas wishing to testify in neutral? Seeing none, AVH, is there anyone on the line wishing to testify in neutral to SB 278?
To provide testimony in neutral for Senate Bill 278, please press star 9 now to join the queue. Chair, there are no callers choosing to testify at this time.
Thank you. At this time, I'll ask the senator if she has any closing remarks. It doesn't appear there's any, so at this time, we'll go ahead and close the hearing on SB 278. At this time, we have arrived at our last item on the agenda today, which is public comment. If you're wishing to testify in public comment, please note that you are being asked to state and spell your name, state your affiliation, if any, and you will be provided 2 minutes for public comment. At this time, I don't see anyone here in Carson City. And I do not see anyone in Las Vegas. AVH, is there anyone on the line wishing to testify in public comment?
If you would like to provide public comment, please press star 9 now to take your place in the queue. Chair, the public lines are open and working. However, there are no callers choosing to provide public comment at this time.
Thank you. With that, members, any closing comments? If you didn't know, our secretary is also a personal trainer. So you could definitely go to Mr. Lindsley for personal training advice and fitness. He has a good protein regimen and can provide plenty of support. And with that, I see no other additional comments today. So with that, we will go ahead and close the hearing. Thank you for being here.